everyone. Thanks for joining Adam and I today on another episode of our Nonprofit Fundamentals video series. Today, we're joined with Brittany Naimoli. She's an attorney at the Chilla Business Counsel, and we want to talk to Brittany because she is an attorney in the labor and employment area. And so, with payroll being one of the largest expenses that our nonprofits tend to have, I think Brittany is going to be able to provide a lot of insight for us into employee law. So, Brittany, thanks for joining us today. Can you give us a quick little intro about you and how you got into business law?
Yeah, thank you, April. So I'm Brittany Naimoli with Chilla Legal. We represent employers, nonprofits with labor and employment issues. I went into labor and employment because I found it very interesting. And based on our conversation today, you will see how interesting it can be. And
Yeah, interesting and complicated.
there's that.
Yeah. So I think let's kick it off with, what is the difference between an employee or an independent contractor? Because again, nonprofits have a lot of employees, they have people or volunteers helping out. How do you draw that line between who's an employee and who would be considered an independent contractor?
So this is a topic that comes up a lot, and I'm not sure if you guys ever heard of the Jersey Shore decision with the court reporters, where the Department of Labor came in and said that court reporters are no longer independent contractors. And we were actually on the forefront of that argument, and the judge decided that they are. So they use a three-part test to make this determination. So independent contractors, as like their name independent, they usually have control over what they're doing. So where they're going on a day-to-day basis, whereas an employee comes in 9 to 5, this is what you're doing. And I'll
Mhm.
use the example of the court reporters. You call them up and tell them you have a case, and they might decide that day, I don't want to work, so I'm not going to. Um, Next is the services that they provide, where it's kind of outside the usual course of the company's business, um, or actually where they're located. So, for example, you need a court reporter. I'll say you're a court reporting agency and you need a court reporter. They're going out to, say, my firm to report the deposition and things like that. So they're not at the court reporting agency's place of business, they're working outside. So employees are generally inside, or remote working kind of complicated that, but I think you get what I'm saying. And then third, they're established. So using the same example, the
Mhm.
court reporting agency doesn't want to use you as a court reporter anymore. Well, that's okay, because April can go work for someone else at any time or pick up her own clients. You have
Mhm.
your own business, you're able to find business and continue profit.
Mhm.
Whereas the employee, you get terminated, you got to go find a new job.
Mhm. Yeah. So three-part test, not so easy.
Not
A little
so easy,
complicated.
Yeah.
especially when the Department of Labor gets involved and wants to complicate everything.
Yeah, that doesn't sound enjoyable. So going more to the employee side of things, so right now we have a lot of nonprofits who are either potentially looking to expand to other states. Maybe they have a remote workforce now, especially post-COVID. So what should nonprofits keep in mind when they have employees in multiple states?
Keep in mind the different benefits or labor and employment laws that may apply based on the state the employee is in. Um, New Jersey is very liberal in their employment laws. So I will use the example I used earlier. Pennsylvania doesn't have a sick leave law. New Jersey has the 40-hour requirement. And then New York has even more to offer. So it's going to be kind of hard if you're an employee company or a New York company to not abide by other states' laws already based on what you're providing your New Jersey and New York employees. But it is always important to be mindful that there may be that one state that right now I can't even think off the top of my head that has a better employment law that provides more benefits to the employee. Um, the best way to kind of be conscious of that is to work with an employee or an employment attorney, or at the very least, have an HR specialist that is able to navigate the different laws in each state.
Mhm. Yeah, I'm sure using like a PEO company would have that experience and expertise in various states.
Yeah, at least they can kind of navigate and know whether there are specific laws in each state that need to be covered.
Mhm.
They don't know all of the legal aspects that go into it, but at the very least, I would have an HR consultant on hand.
Mhm. And how do you determine like where an employee resides, right? So I guess remote work is more common now. If you have someone working in Pennsylvania and an office is in New Jersey, do they automatically have to follow the Pennsylvania law?
So this is very complicated now. So for example, I live in Pennsylvania. I work remote a lot, remote right now, but I go to the New Jersey office. So since I go to the physical office and I work for the New Jersey office, I am under New Jersey law. However, this gets complicated with taxes. Because we have reciprocity in PA with New Jersey, I only have to pay PA taxes. I do not pay New Jersey taxes. So
Mhm.
the the answer is it really depends, and I know that's attorney's favorite answers, but it really does. We had a case where the employee originally worked in New Jersey. He then moved to Florida and tried to argue Florida law applied. It didn't. New Jersey did. He worked for the New Jersey office and moved after the pandemic.
Mhm.
Um, if the employee is remote, say you're in New Jersey, you hire a employee in Minnesota and you do not have a physical office in Minnesota, the Minnesota laws will apply to that employee.
Mhm.
But again, determining whether you need to apply additional laws because New Jersey might already have better laws depends on the situation.
I like how it's all very complicated.
Mhm.
I never thought that labor and employment would be that complicated, but it definitely is.
I see that.
Mhm.
So with all these complications, different scenarios, how can nonprofits best protect themselves from any potential legal claims from either existing employees or former employees? What can they do?
So, in terms of what employment law would apply, you can always have the employee sign an agreement that New Jersey law applies to any claims. That could be in an NDA, or a confidentiality agreement, or the employee agreement in general. Um, always have everything written down. Please,
Mhm.
you have a conversation with one of your employees about anything, especially if it could lead to some kind of discrimination claim, follow up with some kind of email, letter, anything indicating that it took place. You never want to he said, she said kind of situation. Then you end up in litigation, and most of the time it's going to end up settling, which isn't good for the company because you're forking out money that you shouldn't have to pay in the first place.
Mhm.
But if
Right.
you put it all in writing, it's going to help.
Yeah, a cost that probably could have been avoided.
Yes, majority of the time.
Mhm. Yeah. So documentation is key.
Always. And that's in anything, not just labor employment. Anything you could get sued for. In
Mhm. We
writing.
know we're auditors.
Yeah,
Yeah,
audits,
right.
document.
Yeah.
Hmm.
Okay. Are there any new laws and regulations, maybe in the New York, New Jersey, Pennsylvania area that you can think of that an organization may not be aware of yet?
So there is two. New Jersey has the transparency law that went into effect June 1st. Um, that requires employers to provide the salary, at least a range. Now, we're not quite sure what that range may be right now. So, I mean, it's a little sticky there. But you also had to provide the benefits of what the employee would get within 12 months.
Mhm.
That's generally 401, medical, dental, vision, that kind of stuff. Um,
Right.
The issue with this is if you don't provide the transparency, there's civil penalties. How they're going to implement that, I'm not quite sure because, again, we don't know what the range is. What if you put 5,000, 95,000, and you're somewhere in the middle and then someone sues you because you weren't actually transparent? I mean, that's a $90,000 discrepancy, but who knows? Back to the civil penalties though, it's 300 for the first offense and then 600 for the second offense. So
Mhm.
it's a little bit for not
Yeah.
putting the salary range on.
Yeah, it's a pricey mistake.
Yeah. There's a second one that I don't know if anyone's really heard about. New York now has a prenatal law. Um, so individuals who need prenatal care are provided with 20 hours of paid leave. And it only applies to the individual needing prenatal. So in New York, you can get the sick leave for pregnancies with both parents, whereas the prenatal is only the individual who needs the prenatal care.
Okay. And back to the transparency and the salary, New York implemented something similar, right? So was that a few years ago?
Yeah, I do recall seeing it. I should know a lot more on that, and for some reason, I just haven't looked into it. But I think New York does.
Hmm. Yeah. I'm
Okay.
curious too, like how they implemented it in New York and if there was any penalties on employers for not disclosing it.
Hmm.
Curious as to how that played out.
That I don't know, but I will say that if New York implements something, New Jersey is usually a little bit behind.
Right.
So I won't be surprised if now with the prenatal law in New York, New Jersey might end up implementing that as well.
Hmm. Yeah,
Okay.
which is true. Yeah, everyone here in the tri-state area, right? New York, New Jersey, Connecticut, Pennsylvania, um,
Hmm.
likely have similar laws.
We're all
Yeah,
very
it's
interconnected.
except Pennsylvania. Pennsylvania is extremely far behind, and I don't see them moving anytime soon.
Okay. Yeah.
So, is there any new trends or new issues or I don't know, you have a crystal ball or something, but anything going on in the future that nonprofits should be aware of that this could be a situation that could be occurring?
So there is a common issue, and this goes for nonprofits and for profits and government and everyone in between. Um, Employers are classifying their employees incorrectly and putting them as exempt, which means you get a salary with no overtime abilities. There's only three exceptions to overtime. It's administrative, executive, and then professional work. Um, it's not as easy as it sounds. Like just calling someone an administrative like assistant doesn't mean they're doing administrative work. So there's a whole test under each one. Besides professional, I mean doctors, lawyers. Um, but
Accountant.
there's a test.
Yes.
Yeah, right. There's a test for each, and you really just have to take your job description and match it up and make sure that it fits because you don't want to be having someone exempt from overtime that isn't supposed to be, because if they ever find out, that's a claim against you and it could be a lot of back pay.
And is that what's happening? They're putting them as exempt when they likely shouldn't be?
Right. So that does happen, or vice versa. So the company's losing money because the individual is having all this overtime and they should be actually salaried.
Hmm.
Oh,
So you've seen it go both ways.
Yeah.
that's interesting.
Hmm.
Okay.
Okay.
Yeah.
So I think we're getting close to the end here. Do you have, as a final question, any good stories to share?
Mm.
Put you on the spot right now.
Um, I don't have, I'm not going to go into a good story detail. I have a tip. Um,
Okay, that's fair.
Nonprofits, especially, please do background checks on individuals that you are employing. And I can't quite go into detail why I'm giving that advice, but
Hmm.
it's something that should be done across the board. But please do the background checks on your employees.
Yeah. For all positions?
Those in higher executive positions, especially, or anyone who's going to have confidential information, or anyone working with minors. I'm pretty sure they already do that if you work with minors, but
Mhm.
just in case.
Yeah, absolutely. Yep, good tip, I think.
Definitely a good tip.
Yeah. All right. Well, Brittany, thank you so much for joining us today and telling us a little bit more about what you do as an employment and labor attorney. So thank you for joining us.
Thank you.
Thank, thank you so much.